The lawyer representing South African champion runner Caster Semenya said she's disappointed with the reaction by World Athletics to her client's landmark win at the European Court of Human Rights on Tuesday.
This is a landmark win, obviously for Caster, but for athletes more widely. And the reason for that is because until now, athletes operated, and sporting people more generally, in a sort of human rights vacuum. It was in the gift of sports federations and organisations like World Athletics to say, well, we decide if human rights may or may not apply to you. It's up to us.
The European Court of Human Rights decided that Semenya was discriminated against by rules in track and field that force her to medically reduce her natural hormone levels to compete in major competitions.
The European Court said that's not okay. It's not okay for a whole category of people, in this instance professional sports people, just to be excluded from the protection of the Convention. Professional sports people like Caster are entitled to have their fundamental rights properly considered, properly analysed. In this case, the violations of her rights were Article 8 and Article 14, in other words, her right not to be discriminated against, her right to a private life, her right to a professional life, her right to a personal life. All of those were fundamental rights, and she deserved to have those properly considered, properly scrutinised. They were not by World Athletics, they were not by the Court of Arbitration of Sport, and they were not by the Swiss Federal Tribunal. The court said, that can't happen. That can't happen anymore. There is no more human rights vacuum for professional sports people.
Reacting to the court's decision, World Athletics said the contentious regulations would remain in place.